Thank you for coming. Bonjour. Hier, le vendredi, est-ce qu'il y a quelque chose qui était passé qui était vraiment un choc pour moi-même et pour tous les Canadiens et les Canadiennes qui sont occupés avec la menace de la traite avec la Chine sur investissement. The Canada-China Investment Treaty is many things, but most of them have not been mentioned either before or since ratification. So I'd like to spend the time we have this morning in clarifying for Canadians, unfortunately, when it's too late to do anything about it, why I've been fighting this treaty since before it was tabled in the House of Commons. I noted on the front page of the Globe and Mail, I don't even know if it was the front page complicated it, a report from September of 2012, a reporting on the Prime Minister's trip to Vladivostok, where he and President Hu of China witnessed the signing of the Canada-China Investment Treaty. I asked in question period, at the first opportunity in September of 2012, before the treaty was tabled, when we would see the text and when we would have an opportunity to debate and vote on this treaty. The treaty was tabled so quietly, I'll never forget it. I was sitting in an almost empty House of Commons when not Minister Ed Fast, not the Prime Minister, not even the Parliamentary Secretary for Trade stood up. It was Deepak Oberoi, Parliamentary Secretary for Foreign Affairs, who stood up in routine proceedings and said, Mr. Speaker, there are a few routine matters here. I'm tabling the Canada-China Investment Treaty and a few others. Then I read the treaty. Then I went to the Criminal Code just to verify. I went to look up the official legal definition of treason. It doesn't apply. But this treaty sells out Canada's sovereignty for the next 31 years. I asked twice for the Speaker to allow an emergency debate. We tried to do everything we could to get this treaty before the Trade Committee. Thanks to Liberal MP Wayne Easter, they actually had 1 hour with trade experts, 1 hour before committee, in which they obfuscated and ducked the obvious questions. So let's just review what this is. Unlike some of the media reports, this is not a trade agreement. A trade agreement opens up new sectors. A trade agreement would say, there's something wrong with the fact that Chinese state-owned enterprises can buy into Canada's energy sector, but Canadian companies can't buy into China's energy sector. A trade agreement would be about trade liberalization. This is not a trade agreement. Another myth out there is that we needed this agreement in order to expand trade with China. The United States has much more trade with China than we do. Australia has 10 times the degree of trade with the People's Republic of China that Canada has. Neither China nor the U.S. have entered into an investor-state agreement with the People's Republic of China. Another myth out there is we sign these all the time. In the words of patented PMO script, this is a standard FIPPA. Now, since the concept of an investor-state agreement is by definition anti-democratic, telling someone concerned about the Canada-China Investment Treaty that it's a standard FIPPA is like telling someone who's against capital punishment, this is a standard lethal injection. What's your problem? FIPPAs are by definition anti-democratic. Trade lawyer and expert Stephen Harper has said, quote, they are fundamentally corrosive to democracy. Why? Because they give foreign corporations the right to sue democratically elected governments for damages, not because of discriminatory measures to trade, not because measures are arbitrary or unreasonable, but because a foreign investor has decided that they are unfair in reducing their expectation of profits. So, the so-called long list of these investor-state agreements, why would the Green Party be so concerned about one with the People's Republic of China? Because after all, you hear them say, we've entered into so many of them, such as the Canada agreement with Trinidad and Tobago, Uruguay, Barbados, Benin, Costa Rica, Ecuador. No threat to our sovereignty here. Now, there's a threat to the sovereignty of the people of Barbados, Benin, Costa Rica, Trinidad and Tobago. Any country that signs these with a larger economic power, I think their own democratically elected decisions are going to be subject to potentially multi-million, multi-billion-dollar suits on the most arbitrary of grounds. Why do I say this? There's empirical evidence for it. a very substantial study of the now hundreds of investor-state disputes that have been resolved by 3 people, arbitrators, in a hotel room somewhere, $1,000 an hour international lawyers. The review of these in a report from a European think tank called Profiting from Injustice makes it clear that there's a pattern. The bigger economic power wins, almost all the time. So if we go to Chapter 11 of NAFTA, which was the first of these anywhere in the world, Canada has lost numerous Chapter 11 cases against large U.S. corporations. The first of these was settled. That's another thing that happens. Canada caves all too frequently. This was on a manganese-based gasoline additive. When I was executive director of Sierra Club of Canada, we worked hard to get banned in Canada. The manufacturer decided, Ethel Corporation of Richmond, Virginia, that it was an investor within the meaning of Chapter 11 of NAFTA. Now that's unusual because the people who negotiated NAFTA didn't think Chapter 11 would be used the way it would be used. An investor, they thought, was someone who'd actually built something in Canada. But Ethel Corporation of Virginia merely sold their manganese-based MMT into Canada, then managed to convince Canada that this was an arbitration into which we should enter, and convince the arbitrators to accept the dispute. So that's the first of them. Ethel Corporation of Richmond, Virginia sued Canada when we banned a toxic gasoline additive, resulting in Canada repealing our legislation, paying, I think it was $12 million to Ethel Corporation, which was taken out of the A base of Environment Canada, feeding into another of my concerns with these kinds of agreements. They have a chilling effect. The regulators who banned MMT aren't very likely to have banned another toxic substance where a U.S. corporation could bring a charge against us. We also issued a letter of apology, by the way, to Ethel Corporation, saying there was nothing wrong with MMT, when in fact there's quite a lot wrong with MMT. That was the first. Then there was S.D. Myers, PCB, destruction company in Ohio. There's Abitibi-Bowaters. There's a lot of them where Canada has lost. We've paid out tens and hundreds of millions. What's interesting about this lopsided nature of the deal is no matter how often Ed Fast tells you this deal will protect Canadian companies in China, look at the record. No Canadian company has succeeded once in a Chapter 11 case against the U.S. The larger economic power almost always wins. The largest of these dispute resolution settlements from an arbitration panel was the one with Occidental Petroleum and Ecuador in the fall of 2012. The arbitrators agreed with Ecuador that Occidental Petroleum had violated its contract with Ecuador, that the contract violation in leasing out part of the lease they had under contract with Ecuador to an Alberta company actually violated the terms of the contract, and that under the terms of the contract that was grounds for rendering the whole deal void. Arbitrators agreed that Ecuador, under the terms of its contract with Occidental Petroleum, was taking a legal step in throwing Occidental Petroleum out of Ecuador. But they went on to say it was really a disproportionate reaction to void the contract and throw Occidental Petroleum out. So Ecuador ended up owing Occidental Petroleum $1.77 billion. These deals are appalling by their very essence of giving foreign corporations the right to sue governments. But the Canada-China Investment Treaty is no ordinary FIPPA, not when it's not only a larger economic power, but a communist nation in which all of the so-called investors from the People's Republic of China into Canada will be state-owned enterprises of the People's Republic of China. The boards of directors of PetroChina, CNOC, Sinopec, all currently investing in the oil sands, are appointed by the Communist Party of the People's Republic of China. The Politburo controls all of these corporations, regardless of whether they're Sino-Forest or Sinopec. They're all controlled by one central brain, which happens to be the government of the People's Republic of China. This treaty is unlike all the ones between NAFTA and now, in that after NAFTA they decided that FIPPAs would require transparency and the fact of an arbitration would be made public, not the Canada-China Investment Treaty. NAFTA allows a 6-month opt-out clause, not the Canada-China Investment Treaty. We're locked in for a minimum of 15 years, at which point a future government would give 1-year written notice to the People's Republic of China that we wanted out. After the 1-year written notice, any existing investments from the People's Republic of China into Canada will be protected for a further 15 years. This locks us in for 31 years. Folks, I'm 60. When I'm 91, we may be able to see the end of what Stephen Harper has done to Canada's sovereignty in making us beholden to Beijing to ask if we can please improve our environmental laws, if we can improve our labor laws. The only way to get out of this treaty is to reopen the negotiations with Beijing. So why is it that this was ratified on a Friday afternoon when after almost 2 years I thought that the good work of a number of conservatives, whom I won't name, in deference to their career advancement under the current regime, I thought they'd done a good job of convincing Stephen Harper this shouldn't have been signed. I also thought they wouldn't ratify it before the Hupakasset First Nation court case was resolved, in which the Hupakasset First Nation alleged what, by the way, provinces should have said something, that they were not consulted in advance and therefore it violated their charter rights. Here we are, it's been ratified on a Friday afternoon, and why the rush? As I suspected, the media has confirmed this. Our relations with China were going sour this summer. They charged that nice Canadian couple, the Garretts, with being spies and put them in jail, and that's a strain on our relations. And then, our spy agency, CSEC, had the temerity to say out loud that the People's Republic of China had hacked into the computers of the National Research Council, potentially stealing patented Canadian technology. Now, we know this has happened before. Where are all the jobs at Nortel? It wasn't the only factor, but it was certainly a contributing factor to the loss of Nortel, one of our great Silicon Valley North pioneers, that Chinese hackers stole a lot of their technology. But in the brave new world of Canada's relations with the People's Republic of China, to say out loud that the Chinese government had stolen technology and secrets from Canada is to offend the People's Republic of China. And to make up for the offense, to make sure that Stephen Harper's visit to China in a few months goes well, ratify an agreement that locks us in for 31 years. This is about as bad as it could possibly get for a whole range of issues before Canadians today. What we do about it from here is going to be very difficult. But it does start with understanding exactly how bad what has happened really is for Canada. C'est une menace contre la souveraineté du Canada. C'est un défi grave contre les mesures pour protection de l'environnement, pour la protection des droits humains, pour la protection des droits des travailleurs. Toutes ces choses sont maintenant faites. Les jeux sont faits. Now we have to figure out what do we do about it. We have to know how bad it is. We have to put maximum pressure on all the other political parties to commit that they will never allow an agreement, even the first phase of this, which, by the way, is 6 months of diplomatic wrangling. That's new. Other FIPAs don't contain that. So that Beijing and Ottawa in closed-door sessions will probably decide, and I think future governments will cave, how many billions do you want to pay to protect that law you just passed? With that, I'll be happy to stop and take your questions.
I guess the first one, when it comes to some of the provinces, why weren't some of the premiers open to discussing and saying, well, too early? Basically, is there any documentation or any sort of suggestion that they have?
There's a standard consultation mechanism, the Federal Provincial Trade Committee. When this was first tabled, and I should say publicly a vote of thanks again to Professor Gus Van Harten, who's been very outspoken on this. And in conferring with him, he said, you've got to get some of the provinces to step up. I called, my chief of staff called every premier's office across Canada to see if any premier was willing to speak with me. Only one was, but I did speak with 2 provinces' senior ministers. The extent of the consultation was only through this routine, lower bureaucratic mechanism. One of the premiers was completely unaware of the treaty at all. The others were unaware of the ways in which I thought it would function. That was another reason I thought perhaps they were delaying ratification, was that at least one of the premiers, not publicly but privately, might have spoken to the Prime Minister and said, this is not going to be a good deal for Canada, we don't want this ratified. They certainly weren't informed at anything like the level of Premier to Prime Minister in any kind of conversation that highlighted the risks of this treaty.
Sorry, I wasn't sure what you meant by the 6 months of diplomatic wrangling that's to come. What is that?
That's the beginning of the process under this treaty. So the I should say, of course, Canadian companies, and this is something that, of course, I passed this quite a lot. Canadian companies do have the ability to sue China, but again, my reference: no Canadian company has ever succeeded in a Chapter 11 suit against the U.S. I don't think there's a chance that any Canadian company will ever succeed in protecting any of its rights based on this agreement. But if you go back to, let's see if I the provision where it starts. By the way, another thing I should have highlighted is that Article 3 of the Convention commits Canada to encouraging Chinese investment within Canada. Once there is the launch of a case, the first phase is a 6-month bilateral government to government. And I'm just trying to find the...
Before it goes to some kind of arbitration.
Before it goes to the arbitration. So that's one of those places where I think it's quite likely, given our history with other agreements, particularly Chapter 11 of NAFTA, that the Canadian government would decide not to here it is. It's Article 15, John.
Thank you. That's fine. I think I understand what you're saying.
All right. If the dispute cannot be thus settled in 6 months, then it goes to the arbitration panel. Yes.
Given that Canadian companies want to go there, they want to invest there, and they face official and supposedly illegal efforts to absorb their IP or otherwise infringing the business, what's an alternative to investment treaty? What can they do?
Deciding not to invest in a country that doesn't have reliable rule of law. The Canada-China Investment Treaty will flat out not protect Canadian companies. It's not just my opinion, it's the opinion of Professor Gus Van Harten. And again, based on the pattern of arbitration decisions from these investor-state agreements around the world, the smaller economic power doesn't win. Now, whether that economic power is represented by one of its own companies or by the whole apparatus of its government. So Occidental Petroleum beats Ecuador. SD Myers beats Canada. This is the pattern of what these investor-state agreements do. I don't think, it certainly doesn't, it also locks in, it starts at a point of locking in discriminatory measures against Canada in the very way that Canadian companies have to operate in China. So while Canada can't say, our operations in Canada, if you're the People's Republic of China, you must use local labor, you must meet performance requirements here in Canada, China's allowed to say all those things to Canadian corporations. So it starts out lopsided, but even if you believe for a second the idea that a Canadian corporation is going to be able to sue and get Beijing to cave, you have to start with the 6-month period of diplomatic wrangling. So Canada and Beijing are in negotiations. This is the very large difference between this and other investor-state agreements. Because when a Canadian company sues China, or a Chinese corporation sues Canada, you're not going to be dealing with a corporate entity that's distinct, like Ethel Corporation, or SD Myers, or Abitibi Bowaters. You are dealing with the entire People's Republic of China governance through Beijing. They're all connected. So it makes a very different, not level playing field. There may be some miracle case out there that some Canadian corporation will be eventually have some benefit out of this treaty. But I'll bet you $1,000 right now to your favorite charity that no Canadian corporation will ever win an investor-state agreement versus Beijing.
Another question. You ended up mentioning the First Nations case, which is kind of interesting. What happens with that if it does go forward and if it does and they are successful? How will that end up changing, or will it change?
It can't change anything. This treaty trumps court decisions. Beijing now has the right to sue us if one of our court decisions costs them money. It has the right to sue us if a First Nations decision or a municipal bylaw, provincial law or federal law, territorial decision, if any of them hurt China's expectation of profits of one of its state-owned enterprises. And there's nothing in this agreement that mitigates against frivolous suits. Right? There is nothing lost in mounting an arbitration without good grounds. So the only silver lining I can see in the delay that took place over the last 2 years, and thanks to the Hupacassett First Nation for their valiant efforts, the only silver lining I see is that the Supreme Court of Canada ruled on the Silcotin, the Chilcotin land claim and clarified that title means title for First Nations before this monstrous act of ratifying the Canada-China FIPA. So now we know, I mean, People's Republic of China could still launch an arbitration against a decision down the road where a First Nation says you can't put your pipeline across our territory. But at least the Supreme Court of Canada's decision stands as in law the state of affairs before ratification. If the Hupacossett First Nation appeal succeeds and it's found that the Government of Canada violated its fiduciary responsibilities to the Hupacossett, it doesn't affect the ratification of this treaty. And I know that some other people have said that when they become Prime Minister, they'll rip it up. This is not something you can rip up. You need to understand again, and I think it's important for Canadians to understand, because I've seen, on social media, right away people are saying to me on Twitter, well, we'll just rip it up. No. If you tried to rip this up, immediately the People's Republic of China would bring an arbitration against Canada under the terms of the agreement, which we would of course lose. And the judgment against us would be enforceable in over 100 countries around the world through other agreements. We got out, Stephen Harper left Kyoto not because he ripped it up, because the terms of the treaty allowed for 1 year written notice to then withdraw from the treaty. We are locked in for 31 years unless Beijing says we can get out. I wish we could have had more concern before ratification, but when it comes down to it, ratification of this treaty and not allowing it to be put to a full vote after proper study in the House of Commons is because this class of action within the Government of Canada is under royal prerogative. So while all previous Prime Ministers would have put a treaty of this importance to the House and to the Canadian public for debate and discussion, Stephen Harper knew he didn't have to, because he was exercising his royal prerogative as a monarch, but not as Prime Minister in a Westminster parliamentary